Now, as the cannabis industry continues to mature, you're going to see a fair amount of businesses that look at their books and say, hey, I'm not really sure this is working out. Now, whether that's an investor that starts that conversation or a co-founder of the business, that's not the most important aspect. It's important to understand that cannabis-based businesses cannot file for bankruptcy protection. So the next best option is receivership. So in this video, we're going to discuss the role and the powers of a receiver once they're appointed by the court into the business. Now, if you have any questions about receivership for cannabis businesses or receivership for cannabis business investors, please reach out to us via our website at greengrowthcpas.com or give us a call at 800-674-9050. Let's hop right into the presentation. Today's topic is going to be the role and powers of a court-appointed receiver, and this presentation is brought to you by Green Growth CPAs. Now, as we've covered in previous videos, receivership is a financial process in which a trustee legally is appointed by the courts to restructure a company to attempt to have it avoid bankruptcy, or in cannabis businesses' sake, total illiquidity, or have it kind of be turned around and brought back to success. Now, as you understand, cannabis businesses cannot claim or file for bankruptcy, so receivership is that next best option. And with all the markets kind of going down, you're starting to see more businesses look into receivership as they're settling certain legal things between investors and founders, or between two founders having these issues. Receivership helps them kind of untie those debt obligations and wind the business down. So in this video, we're going to discuss the role and the powers of a court-appointed receiver and how that can benefit the business. But before we do, I need to let you know that the information contained in this presentation is meant for guidance purposes only and not as professional legal or tax advice. And further, it does not give any personalized legal, tax, investment, or any business advice in general. So with that out of the way, what we're going to cover again in the video is the role of this receiver and then the explicit powers that this receiver has once they are appointed by the court. So first, the role of a receiver. Now, a receiver is appointed by a court to help work out the financial details of some pending litigation. For example, maybe an investor sues a business owner for gross negligence or fraud, and then a receiver is appointed to step in and take the business over and preserve its value while litigation plays out, or maybe even help sell off assets to cover some of the damages from the pending lawsuit. Now, you may or may not know this, but the cannabis industry has tons of fraud in it, from tax evasion to ripping off investors to ripping off co-founders. But these people will get caught at some point. There are many paper trails that always lead back to the bad behavior. They may be making some bad choices, and one of those bad choices is not covering up their tracks. Now, a basic financial audit requested by an investor could help turn over some stones that lead to the specific actions of fraud or deceit, and this is where a receiver can come into play. Now, a receiver gets their orders from the court, and a receiver's job is to oversee the recovery or closing of a business. And again, remember that this receiver is put in after some type of litigation happens. So let's just go down the pathway of maybe an investor or a co-founder is being ripped off by one of the other business operators. Now, when they're doing this recovery or closing of the business, they have the ability to liquidate property, pay off the creditors, and deliver any remaining value to the shareholders. Now, all management decisions are made by this court-appointed receiver, so any power held by your current directors or owners of your business are then reassigned over to the receiver by that court order. Now, the court may also allow the receiver to borrow funds to help keep the organization running while trying to sort out any ongoing claims. Now, a receiver may participate in legal proceedings by or against the company. So going down that pathway of an investor being ripped off or a co-founder being ripped off by another business operator, if a financial audit reveals embezzlement or fraud, then the receiver will be the one who brings those lawsuits against the liable party or parties. Further, the receiver can also sell any of the organization's assets and settle claims on behalf of that organization. So depending on how these legal proceedings shake out, they may have to sell off all or some of the business's assets to cover those claims. Now, one aspect that is critical to the role of a receiver is neutrality. Now, a receiver must not have any relationship with any of the parties or court or own any interest in the business that they are becoming a receiver of. In addition, the receiver must avoid all possible conflicts of interest and disclose any potential conflicts at the time of their appointment by the court. There can be no conflict of interest for a receiver, the business, or otherwise. They have to stay neutral. And a receiver is prohibited from financially gaining from their position or from using their position to benefit family, business associates, or other social relationships. Now, receivers don't work for free. They are paid a percentage of the business that they sell off, but they're not getting rich. You're not going from being a broke receiver to becoming a bazillionaire by doing one deal. So now that you understand the role of a receiver and how they get put into place, let's talk about some explicit powers that a receiver has. And in the previous slide, we covered some example powers, but here I want to give you some explicit powers that a receiver has. And these powers are wide-ranging and broad. And the bottom line is that your receiver will basically have full control to run the business, dispense of your assets, settle legal claims, and run your cannabis operation as they see fit. Or if this is for another type of business, run that business as they see fit. So the first power is that they take on the role and exercise all of the powers of the chief officer and managing director positions. They manage the day-to-day of the company, operations, along with the receivership process. So they don't just settle any legal claims, they become the operator of the business. And this includes running the day-to-day operations of that business, hiring and firing, making deals, selling product, and much, much more. Essentially, the receiver is now the senior team and the operations team. Now, number two, believe they don't have to do this alone. They will bring in a team or group of people to help with specific functions. They're not Superwoman, they're not Superman. They need domain expert teams to help out with what brings me to my next point. They can employ other professionals such as attorneys, accountants, and tax advisors to provide assistance throughout the receivership process, hire and fire other employees to manage the organization during the receivership as needed. If they need to bring in a master grower to make sure that the operation is running properly because maybe there was some diversion of product by the other master grower who's been then removed since they figured that out, they can bring someone else in. They have that ability and that power. Number three, the receiver can borrow funds to meet the ongoing administrative expenses and other cash flow needs of the business. And this is critical when they see an opportunity to turn a business around or save the business instead of closing it down and liquidating it fully. Number four, receivers can pay what is needed to preserve, conserve, protect, and improve the business's assets and property. So if they need to rent a security team to protect a grow op, they can do that. If they need to store some kind of equipment or machinery in a secure location, they can do that. They can do whatever they deem necessary to preserve and protect that business's assets because that is where the bulk of the money potentially is for the business. And so they need those assets to potentially sell later down the road depending on how this litigation plays out. Number five, the receiver has the power to pay off and discharge any liens, claims, or charges of any nature against the organization's assets and property. Now, the court gives the receiver the power to remove all of these debts so that these assets can be conveyed free of liens or any other claims when the time comes to sell those properties or those assets. This makes selling the business's assets much, much easier and a cleaner transaction and a faster transaction. And there are many nuances to this process because one of the creditors may be the people that has a lien or a claim to the property, and they may be the one that is kicking off that litigation that brought the receiver actually into the process. So this can be a very nuanced and detailed process. Next, number six, they can investigate any legal claims by and against the business, as well as take appropriate legal action in response to such claims. Now, they may not be a lawyer, but they can hire a lawyer to go and actively pursue any foul play or anything that comes up regarding legal claims to the business for or against the business. Now, tying back to that example of an audit that finds embezzlement from the previous slide, again, the receiver will be the one who brings the lawsuits against the liable party or parties and will see it through until the end of that case. Number 7, the receiver will represent in every way the business, its stockholders, and creditors. Everybody gets pulled out of the business except the receiver and whoever the receiver puts into place. Essentially, the receiver is the business at this point. They are the representative, the key point person, the key man, and they make nearly every decision going forward once they are appointed by the court. The board of directors, any other stockholders or investors, creditors, senior team, operations managers, all those decisions and all that power that was held by those people is now reserved by the receiver. Next, number 8, they can sell off a mortgage, deed of trust, stock, debt, or any property, tangible and intangible property, for cash. Now, this is self-explanatory. If they need cash, aside from the borrowing power that's given to them by the court, they can also sell whatever property or assets necessary to come up with that money that they need to take care of any business obligations, whether that's building the business up or winding the business down and liquidating it out to pay off any credits or any debt that the business owes. Number 9, they have the power to purchase or lease office space, cars, furniture, equipment, and supplies, and purchase insurance, professional, and technical services necessary to conduct that receivership. Again, a self-explanatory power, and it builds onto where they can hire in teams, but it goes to show how much say they have in what they can do with the business's budget and choice of what they do with the money and when they spend the money and how they spend that budget. Number 10, the receiver can settle claims against or in favor of the business and get rid of any assets or property that are considered burdensome. Now, an example of this would be a vertically integrated cannabis business. Say that business that we found some fraud in is a vertically integrated cannabis business. And if the receiver finds that the cultivation site is just so mismanaged that it's beyond saving, then the receiver could just get rid of that entire vertical or that entire line of business right away because it's a burden on the rest of the company and its operations, especially if they found some kind of diversion of product in there or the property is not operating optimally and they find, hey, distribution and retail is really where the money is for this particular business. Let's just cut off all of the cultivation site and just get rid of that and liquidate that out. And lastly, number 11, they have the use of the organization's assets to pay all expenses of the receivership. Okay, receivership is not free. It's cheaper than bankruptcy, or relatively, in most times cheaper than bankruptcy. And again, receivers need to stay neutral. So they're not going to come in and make a killing out of this. They're not going to come in and become millionaires off of this. But they will have to pay those people that they hire, those groups that they hire, those lawyers that they hire. And they will get proceeds, or the receiver will get proceeds from the actions that they take, and they will use whatever assets necessary to cover any expenses for that receivership to move forward. Now, hopefully this video has brought you some value and helped you to understand the powers and the role of a receiver once they are appointed by the court and how they actually get appointed and why they are appointed. Now, if you need help understanding if your cannabis business needs an audit or a review of the financials to see, hey, is there some type of fraud or embezzlement, or are the taxes not being done properly that could potentially run into bigger issues later down the road when we go to exit, maybe go public or sell out to a venture capital firm, then please reach out to Green Growth CPAs via our website at greengrowthcpas.com or give us a call at 800-674-9050. As I said earlier, there's a lot of fraud and mismanagement in the cannabis industry. And if you are an investor or maybe you're a co-founder and you suspect something like this is happening in your business, you need to take action sooner rather than later. Because some of these businesses don't have more than 6 or 8 weeks of capital on hand, and it can be really, really quick to run a business into the ground once a founder knows they're potentially under investigation or knows that they're potentially going to get caught. And they think they're very smart, but there's so much paper trail to lead back to those bad behaviors that we will help find that genesis of that bad behavior and help you to remedy it as soon as possible. So if you need help understanding if your cannabis business needs an audit or a review of the financials, then please reach out to us via our website at greengrowthcpas.com or give us a call at 800-674-9050. Have a great day, and we'll talk to you soon.